So today we're going to be talking about recovery of charges by a legal practitioner. So after a lawyer has done work for the client and wants to be paid his professional fees, how does he go about recovering his fees? From the Legal Practitioners Act, Section 16, Sub 2, we have that the condition precedent for recovery of fees by a legal practitioner is that bill of charges must be prepared, which would be served on the client. So bill of charges, of course, is the bill where the client will see the work legal practitioner has done and the cost, the charge for each work done. Now, the procedure for recovery of fees is as follows. Now, the first thing is that the legal practitioner will prepare the bill of charges, which he will then serve on the client. And then after 1 month of service, if the client has not paid the bill yet, the legal practitioner can then institute an action in court for recovery of fees. The court in which the action would be instituted would be in the High Court of the state. Now, if the client disputes the bill, so if the client is not quite in agreement with the charge which has been made by the legal practitioner, the client can apply to the court for taxation of the bill within 1 month of receiving the bill. What is taxation of the court for? A review of the bill of charges, all right? So because he disputes the amounts being charged or the work purportedly done by the legal practitioner. Now, what mode of service is required? Mode of service required is personal service, or the legal practitioner could also have the bill left at the client's last known address. Now, is it possible that a legal practitioner can institute an action within less than 1 month after service of the bill on the client? And the answer is yes. If there are circumstances in which the legal practitioner believes that the client intends not to pay the bill, then as long as he has prepared the bill of charges and there is no problems with it, and then there are facts to prove that the client wants to delay or prevent payment of the bill, then the legal practitioner is entitled to bring an action in court within less than 1 month for recovery of his charges. Now let's have a look at what a sample draft of the bill of charges would look like. So this is what it would look like. You would always have it on the letter heading of the law firm of that legal practitioner. And then it would be dated and addressed to the client. And then you would have the subject matter of the brief. So here, the work that has been done has been in respect of land at this address in Abuja. And then you will have the title, say, bill of charges. Then you would now have the table containing the particulars, the date, and the cost. So the work done would be under the particulars, the dates that work was done, and then the costs for the work that was done. So for every work done by the legal practitioner, you would have the particulars, the date, and the cost entered. And then at the end of it, you would have the total. And then you can now provide your bank details to which the client can pay the money into. So this is the prerequisite, this is the condition precedent for recovery of charges by a legal practitioner. If a legal practitioner has failed to prepare and file and serve the client with bill charges, then he cannot go about recovering his fees. Now, what would happen where the bill of charges does not have sufficient particulars? If the bill of charges doesn't provide sufficient particulars, then it may be irredeemably defective. So the legal practitioner will not be able to recover his fees with such bill of charges. So I hope you've understood this topic, and I'll see you in another one. Bye-bye.